Today's webinar is entitled Ensuring Young People Are Not Criminalized for Poverty, Fines, Fees, and Costs in Juvenile Court. Today we have the Honorable Ernestine Gray with us. Judge Gray, would you please introduce yourself?
Yes. Hello, I'm Ernestine Gray. I'm a juvenile court judge in New Orleans, Louisiana. I have been on the bench since November of 1984 and have heard cases, both delinquency and now primarily dependency cases, but I'm a veteran and a staunch advocate for fairness in the court.
We're very grateful for Judge Gray giving up her time and her expertise to be with us today. She is definitely the expert. And my name is Serena Holte. I'm with the National Juvenile Defender Center, and we have created a partnership with the National Council of Juvenile and Family Court Judges to work together on a variety of issues. And one of those is fees and costs in juvenile court, and trying to ensure that young people and their families are not criminalized for being poor, and that they're able to still succeed and get better outcomes through juvenile court process. So let's get started. Legal financial obligations is a term that kind of encapsulates all of the different possibilities for what we're talking about today. It could include cash bail, it could include restitution, fines, fees, court costs, probation costs, placement fees, all sorts of things. And the legal financial obligations term is meant to just kind of give you a one term that will be good for all of them. Today's conversation is not going to include a conversation about cash bail or restitution. We will keep those for separate webinars. We believe that we'd like those to be eliminated or reduced also, but we have all sorts of other resources and etc. information to share related to those two topics, so they will get their own webinar. Today we will talk about probation and placement fees, appointment of counsel, any fees related to what that might be, whether we're talking about application fees or at the end of a case, depending on how long it is. Some states actually will charge a certain fee for a quote-unquote free attorney. Then there's fines and fees, whether it's a $100 fine for this type of matter or another. Court costs, whatever court costs really actually means. We also have placement and probation fees related to community service fees. And for community service fees, it's oftentimes something if you are have a young person out trying to get their community service hours, sometimes they actually have to pay just to be able to access the community service.
So our concern is that when we charge fees for when juveniles appear in court, we are furthering the disparities that exist around race and class and ethnicity. And this quote, "There can be no equal justice where the kind of trial a man gets depends on the amount of money he has," is one of the things that's really driving our work. We really want judges and courts not to further impose difficulties on young people's lives by assessing them fees and costs that just really send them deeper into a whole series of other problems. So don't assess those fees. And we want judges to recognize that they have a lot of discretion, and they can significantly lessen the harms that are caused young people when we impose fines and fees. The hardships that are caused by the imposition of these fines and fees are tremendous on the youth and their families. And so we want judges to really be conscious when they're ordering fines and fees for juveniles. So a lot of courts started off assessing fines and fees with the hope that they could get money that would fund some of the operations of the court. And I want us to remember that the court is supposed to exist separate and apart from who might be coming to it. And so it shouldn't be funded on the backs of those people who are charged or brought into court for violations. And recognizing that once we assess the fees, if they are not paid, they result in other long-term consequences that are negative to the family. Further shuttling them down into the juvenile justice system, imposing obligations that impact their ability to get an education, maybe even employment. They can result in civil judgments against the family. And if they get civil judgments, they can lead to wage garnishments. And so what we realize and should be cognizant of is that many, many of the people who come to court are really poor and are teetering on, not being able to pay their bills. And so adding another obligation, financial obligation, many times means that this family is going to have to choose between paying rent or buying food and satisfying costs or fees that have been ordered by the court. And we really don't want to put families in those kinds of situations.
I think it's great that NCJ, FCJ has made a resolution. They made a pact a couple of years ago that makes it clear that they're trying to get judges as much as possible to ensure that the youth and families are not being charged legal financial obligations in circumstances in which it doesn't absolutely have to happen. So we're very grateful for this partnership with NCJ, FCJ, and for them having taken the steps to put out this official resolution and supporting this cause.
And what we realize is that while the court might be assessing a large amount of fees, when we look at what it was requiring of the court in order to be able to collect in terms of administrative costs, we were finding that there was not a large return on the orders that we were making in terms of children being cast to pay fines and fees. And so it just wasn't or isn't a good idea for the administration of justice, and doesn't engender, I don't think it doesn't engender in the part of the people who are being brought into court the idea that they are actually getting a fair shot. So I think it goes even to the people's feeling of fairness that they are getting or lack thereof. And so adding these costs and fees, I think, don't really do anything to help people believe that they're getting a fair shot. And so around the appointment of counsel, which I think is probably one of the most important things where many jurisdictions have assessed fees. We know that generally appointment of counsel is supposed to be made available to those who are unable to pay, and they have a constitutional right to an attorney. And in most jurisdictions, that ability to pay is determined by indigency. And so what a lot of us believe, both at the National Council and at the Juvenile Defenders Center, is that young people should be presumed eligible for appointment of counsel. Therefore, they should be deemed indigent, because as a matter of fact, the young people don't have an income. It's really their families that are charged to pay. And so we think the better view is to have the presumption that all young people coming into court are eligible for appointed counsel, and that is without any kind of application fee, qualification fee. In our jurisdiction, we were for a long time, when I first came on the bench, we were charging a $35 fee for every child who came to court who was appointed to be represented by the Indigent Defender's Office. Several years ago, we alleviated that fee and no longer charge that. And so we're not charging either an application fee, nor are we charging for them to be cast to pay later on after representation in the case.
And what we've seen in some jurisdictions is that young people or their family may be more induced to actually waive counsel if they find out that there are fees related to getting an attorney, whether it's the application fee or the fee for your free attorney, that could be hundreds or even thousands of dollars. young people or their families realizing they don't have the funds to pay this. They don't have the money from which, whether it be now or later, to be able to pay for this attorney, may decide, oh, well, I just need to waive counsel because we just need to move on with this and we don't have the money to do so. We never want that to be the reason why young people are waiving their right to counsel. We think it's important, constitutional right for young people to have a zealous advocate on their side to help them through this complicated process. And also, one of the things we've seen in other jurisdictions is young people may even, their detention may be prolonged because of the eligibility determinations to figure out whether your young person actually is indigent. Some applications require all sorts of paperwork to back it up, to prove that you are indigent. And so young people and their families might take quite some time, and then the young person ends up being detained even longer to do that. We think it's a really important piece to make sure that courts are active in helping remove any fees associated with appointing counsel.
And the other I think, Serena, we talked about is that it oftentimes when the parents or someone has to pay for counsel, and you have one child and the parents may have 2 or 3 children, it makes for conflict in the family. So the parents feel that they're having to choose to pay for something for one child and other children are having to do without. And so or the family feel like, okay, I really don't want to put up this money because I don't want to fight this on behalf of the juvenile. And so removing the fees helps to get rid of potential familial conflict, I think.
Absolutely.
So children come into juvenile court, and what we have on the screen is just an illustration of, I guess it's a case flow. And these are the various points in the juvenile justice system where a child might land and will need, we believe, the assistance of counsel. So if you were a child and you were having to go through this maze of the chart, imagine how you would feel if you had to do that without a lawyer. And you need somebody to help you understand what the processes are, what the different stages mean. And we believe that a lawyer is the best person to do that. And that lawyer should be appointed without consideration of the family income. We've said earlier that this appointment of a lawyer should be made without consideration of financial eligibility. And that we should presume that all young people who come to court are entitled to a lawyer and need a lawyer and should have a lawyer without having to pay.
And many jurisdictions have probation and placement fees. These oftentimes are put on a young person at the end of the case where the probation term of 6 months or 2 years or whatever it might be, whether it's done explicitly in the courtroom or whether it's just done administratively by probation, the young person may oftentimes have to pay a monthly fee. We've seen flat fees, we've seen even weekly fees, we've seen a variety of ways in which this might work. There's also what's called placement fees, which oftentimes are if your child is placed in another out-of-home, whether we're talking about the detention center or whether we're talking about a group home or wherever it may be, that those placements also have additional fees. And in addition to that, there's also oftentimes child support that's being charged to the parents when their children are being put into an out-of-home placement. And some of these fees, as we were talking about, actually don't take place in juvenile court. They might be administratively assessed. They might be put on the families just because the child is in probation or just because the child's been put in a placement. Or in the case of a child support order, it's oftentimes being done in a different courtroom than the courtroom in which the delinquency case was heard. And so many times it might not happen in the same place or in the same courtroom And this is where it gets lost. And not everybody understands that these additional fees are being charged in their jurisdictions. It'd be great to make sure that we all know, even though it may not happen in our courtrooms, know what's going on and what probation is charging, what the detention center is charging, what the any of the out-of-home placement options may be charging families, so that we have a better understanding about what's going on and what the harms of these are. The long-term harms of unpaid fees and costs can follow a young person or their family for years. So it's important to know exactly what we're getting into, what our orders are requiring of young people, and what ultimately will end up being the financial cost and obligation related to those things. This quote here is from Commonwealth v. Henry. It's a Massachusetts case from 2016. Equal justice means that the length of probation supervision imposed at the time of sentence should not be affected by the financial means of the defendant. Oftentimes, the fact that probation is continuing, and if a young person's unable to pay whatever those fees are during the time of probation, many times probation will be continued to give them more time to pay. The problem that we've seen there that's ended up happening is they get assessed more probation fees, and they might end up, the system might end up spending more money keeping that child on probation instead of just moving forward and ending the probation, understanding that the young person doesn't have the ability to make those payments. These types of fees can prolong system involvement, increase potential for probation violations, and trap the family in debt. Oh, go ahead.
So one of the things you mentioned, I think is important, that the National Council recognizes this problem all the time. You talked about some of the fees that families are having to pay may be assessed by different courts. Mm-hmm. And so one of the problems that we have, and we talk about a lot, is the inability to know about the number of courts people are in that they have obligations to. And so for the juvenile work, it makes sense to me that some of the courts are more critical. We know that many of our families are in civil court on separation and divorces, they're on child support, and unfortunately, many of our families are in criminal court. So I think one of the things we need to think about at some point is trying to figure out how it is, if we're serious about trying to make sure we're not imposing undue financial obligations on the litigants, is to figure out how we can figure out if they have other obligations, financial obligations in other courts. That's one of our challenges.
Yes, it's complicated. I know my family can be complicated, and I know most families have lots of things going on at once. Exactly. You know, the issue with legal financial obligations oftentimes falls on the back of those who do not have the money to pay, and it disproportionately impacts low-income children and children of color. That ends up being more burdens as young people are trying to become successful. They're trying to further their education. They're trying to obtain housing. They're trying to get a great job. Unpaid fees, fines, costs, restitution, etc., can end up showing up on someone's credit report, and therefore causing issues with the young person being able to get a loan to go to college, causing issues for the young person to get that apartment, or for employment. Now, a lot of employers are running background, in addition to criminal background checks, they're running credit background checks. And so these issues may be coming up in a lot of different areas. So we're trying to just advocate and help people see that the harms caused by a lot of these legal financial obligations can be prolonged and go on for quite some time. We ask the courts and judges as much as possible to exempt youth and families from probation and post-release supervision fees, exempt youth and families from fees for out-of-home placement, and ask courts to not assess probation, post-release, or out-of-home placement fees. Whenever possible, asking you to exercise your discretion in whatever way you can to avoid having to include these fees and place them on youth and their families. So court costs. This is a very ominous thing. Not really sure where the basis of a lot of this comes from. Oftentimes it's determined to be, what's the cost of you going to court? Well, court is expensive, and we understand that, but as Judge Gray said earlier, courts shouldn't be financed on the backs of those who come in, who are charged with offenses and come before the judges, especially not on their own, that the court needs to think about, what are these court costs? What are we assessing against youth and their families, and why? Where does this money ultimately really go? Court costs and assessing these against youth and their families are often geared towards raising revenue rather than addressing public safety. The thought is thinking about, how do we cover the cost of actually functioning as a court? These are constitutional requirements, but yet we're thinking about how to finance them, not through other ways in which we finance functions or requirements from our Constitution. We're thinking about, how can we revert this back into folks who are determined to already not have the means and ability to pay. Court costs can also undermine other conditions placed on youth. These are ultimately becoming debts owed to the court. Young people may be thinking of the court that it's more as a collection agency rather than a neutral arbiter of the law. That they're thinking about the court and the judge and this whole system as being somebody who's more worried about money and less worried about them and their success. And here's where what Judge Gray was talking about earlier comes back, is the concept of procedural justice. When a young person feels that the system is more fair, where they have been heard, even if the outcome is not necessarily what they were really wanting, they will be more likely to comply with the orders of the court. Well, we're talking about orders in which they can comply with. If they don't have the financial ability, they can't comply with a lot of these legal financial obligations. And they may think that the court's more interested in having money than their success. So that may go against their thoughts of the court system really being fair and really looking out for them and their families, and looking for to better the community. So whenever possible, we ask the courts to avoid assessing court costs. Fines and fees. These look different in a lot of different jurisdictions. As I mentioned earlier, it might be $100 for a particular type of offense that a young person was adjudicated for. There may be a victim assessment penalty fee that's required in every single case. We are asking, whenever these are possible, that the court allows for young people to be able to waive them if they're not able to pay. So these end up being economically debilitating, disrupting education and employment opportunities, going back to the time where unpaid fees and fines show up on someone's credit report, that they might exacerbate economic disparities that already enter existence, that have brought the young people into court in the first place. The vast majority of youth in the system are low income. And these oftentimes require families to choose between paying outstanding court debts or paying for food and housing or other necessities. Do not impose any of the fees and fines on youth and their families to generate revenue or impose any sanctions. Condition access to, we should not condition access to judicial hearings or to justice on the prepayment of fees. Where we've also seen fees assessed is when a young person is trying to expunge their record, that they also have requirement to pay fees. We've seen in states like South Carolina where there is a huge fee in order just to ask for an expungement of a juvenile record. We know that there's plenty of collateral consequences that come along with juvenile court involvement, and being able to seal or expunge a record is very important. And it creates more hurdles to the young person's success when we add extra fees in order for them to access, to seal or expunge their record.
Community service. So when I first came on the bench, I remember there was a lot of talk about ways that we would order people to make community service. And there are a lot of stories about the situations in which young people were ordered to clean up along the highways. They were to wear these orange jackets or yellow jackets, which really stood out. And at that time, I think people in the field were really thinking that this shaming aspect would somehow help children improve. But what we have learned over the years, I think, is that the shaming of young people in the juvenile justice system when they come before us is very detrimental, and it doesn't hurt. And so when we're trying to decide whether or not we ought to order community service, I think the things to think about is what are the ways in which we can order the young person to do something that is of value to both him or herself and to the community. And I bring up value to the community because what I really think is important is for the young people to leave the experience with the idea that they have been helpful, to leave the experience with the idea that they can contribute something that is of value to the community. And what that does is help them feel that they belong. So make sure that we're ordering community service for a specific time period, and it doesn't interfere with their school or any other school like pro-social activities like the basketball team or the football team, or a job if they have it, because obviously if they have a job, it's probably very important to them and their family. So making sure that when we order community service, we're not interfering with that. But I do think that having young people engage in community service where they can perhaps engage with a mentor. So a young boy, for example, who's interested in becoming a barber, I think that's a great job. It is a job that lots of people have. And so if someone is interested in becoming a barber, can we figure out if there's a barber in our community who would be willing to work with, have the young person come to their shop, sweep up the hair, but in the process, learn something about running the business of being a barber, what time you have to go to work and be on time. Is it important for you to be on time if you own a barbershop? And do you have to work long hours? Think of ways in which we can really teach skills that young people can translate into the time when they're no longer before the juvenile court. Skills that will help them get a job and become contributing persons in our community. And then if we decide, I'm going to the next one, Serena, yes. Then if we decide in this case, and remember again, every case is individual, we're not lumping everybody together, but if we decide in a particular case that a payment is going to be required, then we need to figure out how best we can make it possible for the young person and the family to meet the obligation that we are imposing. And so when we are ordering payments, we should figure out, is there a payment plan that can help the family meet all their obligations, buying the food, paying the rent, and meeting the fees and fines that have been imposed in this case. So we shouldn't impose onerous user fees or interest. We should figure out ways to allow the persons to make the payments in a convenient way, electronic or web-based. And if in fact we order a payment, we ought to create a possibility for a young person, should circumstances change, to come back into court and ask for a modification. So the dad or the mom gets laid off from work. The mom gets seriously ill, and that is another burden on the family. Allow them an opportunity to come back to court and ask for a modification based on a change in circumstance. And again, we don't want to do anything that is going to shove the family deeper into economic problems. And make sure that, if the parent can't pay any other way other than coming to court, you try to figure out a way that they can make those payments without having to miss work. That's the other thing I think is important when we are working with young people, and when families have to miss work, that means that impacts their income. And so generally our hours are just like business hours. Our hours here at the court are 8 to 4. 8:30 to 4. And so most people are working during those hours, and we need to try to figure out how we can make some things more accessible and convenient for the families to comply with.
And oftentimes the electronic or the web-based payments allows for that. But the one thing we want to always keep in mind too is whether that's charging interest or fees for families to be able to access. to be able to make those payments. As much as possible, we're really want courts to explore what the options are that out there that will keep those fees or interest at the lowest amount possible so that families can easily make their payments with as few fees or interest charged to them as a result.
Right. And so actually that's interesting because I guess my children have moved me into trying to make all my payments by electronic methods. And I'm like, oh no, I don't want to do that. But then when I go to make some of them, they charge you $5 for, I don't want to pay an extra $5. and you know, I have to look, it's not an issue of whether I can or not. It's that I don't believe it's fair to assess me an extra $5 to use this method of payment. And so I think you're right. We need to be careful about the things that we are putting out there. While we think it may be helping the families, we need to look for the things that are behind it, things that we wouldn't ordinarily consider ourselves, but for the parents that we are dealing with, they're critically important. And I think I'm at the last slide. We want to understand that families who are burdened by these obligations may face difficult choices, either paying the juvenile justice debt or paying for food, clothing, and shelter, or other necessities. And I'm sure that most judges don't want to put families in that position. I mean, we don't want them to have to choose to pay a fine or not buy food, because not buying food could land them into another section of juvenile court, the dependency side. And I'm always saying, you know, if we ask the family to do this, then they're going to have other issues that may get their attention by the child welfare side. And we certainly don't want to be responsible for casting a family into the child welfare side and having a child come in to foster care because their family wasn't able to buy food. And to be mindful of the fact that when we are ordering people to pay fines and fees, we may be in fact impacting their educational opportunities further down the line. And remember that when children and families aren't able to pay these fees, there are negative consequences that may follow them well into adulthood. And Serena already talked about a couple of those. I think one of the ones that I think is really important when we talk about the collateral consequences. I know in our court, we were charging a lot for expungements. And I worked with a committee to get the expungement statute changed in the children's code so that courts, including mine, couldn't charge excessive fees for young people to be able to ask for an expungement. I think the expungement is one of the things that, you know, ought to be made available readily to children, and they really shouldn't have to pay for that. And it helps them down the line.
Absolutely. Thank you all so much for joining us today. Judge Gray and myself were here to answer any questions. If you can find the chat box, you feel free to ask any questions, make comments as you deem, and we will be available to answer them now, or as you can see on the screen, our emails are listed, phone numbers are listed. You also will notice that there is a website up here. It's where the bail, fines, and fees bench card that we've been talking about today can be found. You can find a hard copy there, or an electronic copy there. If you'd like hard copies, please feel free to reach out to me. We'd be more than happy to send some your way. This is a bench card that was created in partnership between the National Juvenile Defender Center and the National Council of Juvenile and Family Court Judges. And we really want this to be a resource that courts can rely on to get assistance and guidance as you're looking into how to proceed when you're addressing the legal financial obligations imposed on children and their families. So thank you so much for coming today. And I don't see any questions. Please feel free to reach out to us via phone or email at another time if you have any. I will keep this up for the next couple of minutes just in case anyone is having some issues typing in their question or comment. But we are grateful for your participation today, and we look forward to hearing from you and following up with you about your experiences related to fees and fines and costs assessed in juvenile court, and the long-term harms they may have if young people and their families are not able to pay, and then they show up and end up being money judgments and show up on people's credit reports and cause other issues for youth and their families down the line. Thank you very much. All right, Judge Gray, it's just you and me.
Oh, no questions?